Good afternoon, everybody. I'm your host, the Supreme Litigant, and I'd like to start off by saying thank you for subscribing to my channel, to all of my subscribers. If you haven't, please go ahead and subscribe and go ahead and pound that like button. This video right here, I'm going to explain to you how to beat qualified immunity in this video. But before I do that, I'm going to read to you this right here, what you see on the screen, because I believe this will give you a better understanding of what a reasonable officer is and how the courts came up with this test to determine if an officer acted reasonably, in other words, lawfully, or unreasonably, in other words, unlawfully. Okay? So let's go ahead and start this on off right. The courts require only one thing of officers, that they act reasonably. Thus, the only types of mistakes that may result in suppression are unreasonable ones. In other words, of the U.S. Supreme Court, what is generally demanded of the many factual determinations that must be regularly be made by agents of the government is not that they always be correct, but that they always be reasonable. Okay? Do y'all see this footnote right here where it says 5? If you scroll down here, you'll see this case right here. Okay? If you go and read that case, that quotation, what I just read will be in that case on page 185. Okay? The problem naturally is determining what's a reasonable mistake. The dictionary definition of reason helps a little. The Oxford English Dictionary says that to reason is to think in a connected or logical manner, use one's reason in forming conclusions. Still, the term is necessarily subjective. It all depends on the surrounding circumstances, especially whether quick action is essential. As the First Circuit observed, the term reasonableness embodies a concept, not a constant. It cannot be usefully defined in order to evolve some detailed formula for judging cases. As a result, to determine whether a mistake was reasonable, the courts utilized the old standby, the reasonable officer test. Specifically, a mistake is reasonable if the mythical, reasonably well-trained officer might have done what the real officer did. Okay? To make this determination, the courts usually need to determine two things. What did the officers do? What should they have done? I'm going to stop. I'm going to read this little paragraph right here. This will be the last one right here. I'm going to read this right here, and then I'm going to stop, and I'm going to go to the next document. Okay? Whether officers acted reasonably in a given situation often depends on what they knew. For example, if officers knew that a getaway car in a liquor store robbery that had just occurred was a black 2001 Crown Victoria and the last two numbers on the license plate were 23, their act of stopping such a car would have been reasonable, i.e. lawful. Okay? But if they didn't have a description of the getaway car and instead stopped the car because the driver looked suspicious, the stop would have been unlawful. So what they just told y'all without telling you is that reasonableness in reference, to the Fourth Amendment means lawful, and unreasonable in reference to the Fourth Amendment means unlawful. That is what they just said. On to the next document. Now I'm about to explain to y'all what qualified immunity is. It's right here. Okay, I'm going to read to y'all everything that is highlighted. Okay, this is a Alabama, United States District Court in Alabama. This is a case from that court. Okay, so you'll see a lot of 11th Circuit opinions in here. In other words, authorities. They like to call them authorities. You'll see a lot of those in here because all cases in Alabama, U.S. District Courts, Georgia U.S. District Courts, and Florida U.S. District Courts, all appeals from those courts go to the U.S. Court of Appeals for the 11th Circuit. Okay. The doctrine provides immunity from suit to governmental officials performing discretionary functions as long as their conduct violates no clearly established statutory or constitutional rights of which a reasonable person would have known. The purpose of the doctrine is to allow government officials to carry out their discretionary duties without the fear of personal liability or harassing litigation. It protects from suit all but the plainly incompetent or one who is knowingly violating the federal law. In order to be eligible to claim the benefits of the doctrine, however, the public official must prove that he was acting within the scope of his discretionary authority when the allegedly wrongful acts occurred. Okay, I'll stop right there. The footnote right here, 10. I'm going to read y'all that footnote in a second once I finish reading this paragraph. I think that's a very important footnote. Clearly established law is law that is sufficiently defined so as to provide public officials with fair notice that the conduct alleged is prohibited. If the evidence at the summary judgment stage, viewed in the light most favorable to the plaintiff, shows there are facts that are inconsistent with qualified immunity being granted, the case and the qualified immunity issue along with it proceed to trial. We'll proceed to trial. Anyway, let's go back to this footnote that I was telling y'all about. Okay, because what I'm about to tell y'all is what they have, what they consider clearly established law. So let's say, I'm going to read y'all this again. In other words, qualified immunity shields police officers acting within the scope of their discretionary authority from liability so long as their acts do not violate clearly established law. Okay. Only Supreme Court, 11th Circuit, and Alabama Supreme Court cases can clearly establish the law in this litigation. The reason I have these courts listed is obviously, the Supreme Court of the United States. You already know that one. And because the higher court over this court in which I filed this lawsuit in is the 11th Circuit. So if I appealed in this court, my appeal would go to the 11th Circuit. That's a supervisory court, a superior court. It's a higher court. Okay. And the Alabama Supreme Court, obviously, because I have state law claims in here, such as assault, battery, and, stuff like that. Okay. In this circuit, rights are clearly established by decisions of the Supreme Court, this court, or the highest court of the state in which the case arose. I just want y'all to pay attention to that. And this is 11th Circuit case. That's why you always see me citing 11th Circuit. So if you're in Georgia, Alabama, or Florida, these are the cases that you want, 11th Circuit cases. When an officer asserts qualified immunity, the issue is not whether reasonable suspicion existed in fact. This applies to probable cause too, just to let y'all know. But whether the officer had arguable reasonable suspicion to support an investigatory stop. To determine whether an officer had arguable reasonable suspicion to conduct an investigatory stop, courts analyze whether a reasonable officer could have believed that the seizure comported with the Fourth Amendment. In other words, arguable reasonable suspicion exists if a reasonable officer in the same circumstances and possessing the same information could have believed that reasonable suspicion existed. Okay, if they have arguable reasonable suspicion, they are going to get immunity. Okay, I'm letting you know that. This applies to probable cause too. So let's go on. I want to read you the one about probable cause too. For defendants to be entitled to qualified immunity, actual probable cause is irrelevant since the proper standard is arguable probable cause. Arguable probable cause exists when an officer reasonably could have believed that probable cause existed in light of the information the officer possessed. See how that sounds very, very, very similar to arguable reasonable suspicion? That's because it is, okay? As we frame the concept in Lee versus Ferrero, arguable probable cause exists where reasonable officers in the same circumstances and possessing the same knowledge as the defendant could have believed that probable cause to arrest. I'm sorry, let me read that again because it sounded like I read it wrong and I don't want to confuse y'all. So I'm going to do it again. Arguable probable cause exists where reasonable officers in the same circumstances and possessing the same knowledge as the defendant could have believed that probable cause existed to arrest. Okay? In determining whether arguable probable cause exists, we apply an objective standard, asking whether the officer's actions are objectively reasonable, regardless of the officer's underlying intent or motivation. Okay, and I'm going to stop right there. Okay. In the ultimate facts section of your complaint, let's go back. I want to show y'all what I'm talking about. So let me go here back to my ebook because I've been working on this for you. I've been, editing it. So let me go back down. I want y'all to see what I'm talking about when I say the ultimate facts section of your complaint. Here, right here. In this section of your complaint, you want to allege facts, okay? You want to make allegations against this defendant police officer. And these facts must show that a clearly established, constitutionally protected right of which a reasonable officer would have known has been violated. That's all you want to do. Once you can do that in this section of your complaint, once you can do that, that will prevent them from filing a Rule 12b-6 motion to dismiss on qualified and state agent immunity grounds. And then the case will go on. It'll probably continue for about 6 to 8 months or 6 months to a year. You'll be going through discovery. Okay. So I'm going to give you an example of a clearly established constitutionally protected right. And I'm going to use my case as an example. So this is what happened in my case. So I had just gotten off of work. My car broke down in the middle of the road. About 10 minutes later, a police officer pulls up. He jumps out of his car and he asks me for my ID. And I say, for what? Okay. And he says, because you're broke down in the middle of my highway. And I said to myself, this is what I'm saying in my head. That is not reasonable suspicion for you to ascertain my name. That's what I said in my head or whatever, because I know that being a stranded motorist is not a crime. So since it is not a crime, I don't have to comply with your request. Do y'all see what I'm saying? Okay. So I did give him my first name, but he walked off and he called for backup. So maybe 10, 15 minutes later, his backup shows up, 2 other police officers. They show up. Somebody asks me for my ID again, and I say, for what? As soon as I said for what, everybody grabbed me. Okay. Everybody grabbed me, and my back was already against my car. I'm frustrated at this point, and they just come from out of nowhere and ask me for my ID again. Stuff like that. So one of them had his hand on his gun. All of them surrounded me. And then they asked me for my ID again in a more aggressive tone. And when I said for what, everybody immediately grabbed me. They just grabbed me. Okay, I didn't say much because I already knew what I was going to do. I knew that I had been unlawfully detained, and I knew I was going to sue them, and I knew I was going to win. Okay, that is an example of a clearly established constitutionally protected right, because they cannot detain you without reasonable suspicion unless they have your permission. That is the only way that they can detain you if they don't have reasonable suspicion. Reasonable suspicion is predicated upon specific articulable facts that a crime has been, is being, or is about to be committed. Okay? It helps once you know what the law is. Okay, and I'm not talking about statutes. I'm talking about the common law. That is what I'm talking about. I have read so many cases And I literally just cited y'all the definition for reasonable suspicion verbatim off the top of my head. There is no case. I'm not looking at a case at all right now. I just cited y'all there off the top of my head because I have read that principle in law so many times. So many times. This is easy, man. This is easy. Y'all can do this. I know that you courageous, bold motherfuckers can do this. Okay? I know you can do this. So that'll be the end of this video. The Supreme Litigant is out. Peace.